So good morning, everyone. I welcome you all and thank you so much for joining this monthly session on income tax update and recent notification issued in the previous month. So today we are going to discuss some important case laws which were issued in the month of December and few notification. So there are 5 to 6 cases and 3 to 4 important notification. So first of all, I'm going to discuss the very important case law of Delhi High Court with respect to reassessment. So it is important because there were almost 1300 writ petition was filed before the High Court. So before going to discuss this case law, let me tell you some brief or background about the assessment. In income tax, there are 4 types of assessment. One is simple assessment, which is like 143(1) intimation order. The second is best judgment assessment, when there is no information submitted before the assessing officer, then he pronounce the order under best judgment assessment. The third is normal assessment or regular assessment under section 143(3), wherein the tax officer asks some queries uh, for the previous years, I would say, and when we submit the details and all, so basis the all the those details, the assessment order completed. And the last one and most important and most litigative assessment is reassessment. So what is reassessment? If the assessing officer think that certain details were escaped or certain portion of income has been escaped, so he reassessed, or this is also called as income escaping assessment, and it is like one of the most litigated and most of the lawyer earn income from this assessment only. So prior to 2021 Finance Act, there were 3 time limits. One is 4 years, other is 6 years, and the last one is 16 years. So in case the income is situated in foreign countries, the time limit was 16 years. So now from Finance Act 2021, they have changed, or substituted this section. So they have reduced the 3 condition to 2 condition. So from on or after 1st of April 2021, there would be only two types of time limits. One is 3 years and the other is 6 years. What is 3 years? So if the assessing officer think that there is some income escape, or he has some material record available with him, then he can reassess the income for previous 3 years. And if the undisclosed income is more than 50 lakh, then he can reassess the cases pertaining to last 10 years. So this was substituted from Finance Act 2021. But during the what happened during the pandemic, and the tax officer was not in a situation to issue notices on or before 30th March. So if I would say, for the last the earlier or erstwhile scheme, the time limit was 4 to 6 years, but since the department could not be able to issue proper notices, and the time was barred on 31st of March. So what they have tried, they have, and you also, all of you might be aware that extension was provided to all the SSCs, and there was some corona situation, so department tax officer was also not regular in the tax offices. So what they tried, they have extended the due date. So the cases which were time barred on 31st March, the department through notification has tried to extend the due time limit from 31st March to 30th June. So, but and there were various notices issued to many taxpayers. So first of all, let me brief you what was the amendment or what was the substitution in Finance Act 2021. So as per Finance Act 2021, there were two notification, or I would say two prima facie condition. First, the notice should also, prior to issue notice under section 148, the tax officer should also issue notice under section 148A. What is section 148A? So 148 is like primary queries. So the tax officer will ask certain queries, and if he is satisfied that the taxpayer has escaped certain part of income, or the the SSC has like misreported or something like that, and if he satisfies all those conditions, and he also issues so cause notices, and the taxpayer don't properly substantiate his income part and all, then first he need to issue order under section 148A. Thereafter he will initiate 148 proceeding. So for this, I'm going to read out the background. So as per the Finance Act, the reassessment notice issued on or after 1st April 2021 must comply with those new provision. The new provision which I have already stated, that first of all he need to issue notice under section 148A, and the time period as per the new scheme is reduced from 6 years to 3 years, but that has also extended if the undisclosed income is more than 50 lakhs. So owing to COVID-19 pandemic, the CBDT has issued notification when the last date of issuing notices for reassessment for erstwhile scheme or old provision of section 148 has been extended from March 31st, 2021 to June 30th, 21. So the court has decided the validity, means since the new section has substituted the old section, so the court has held that whether the notices issued under earlier section is valid or not. So there were more than, even prior to this case law, there were also 3 case laws, 2 in favor of SSC and 1 is against the SSC, that is in favor of revenue. So the cases favor was issued by Rajasthan High Court and Allahabad High Court, and the case which was in favor of revenue was issued by Chhattisgarh High Court. So the contention of the SSC was that since the notices are violation of mandatory provision under section 148A, as the new law has been added with effect from Finance Act 2021, and SSC contested that the department cannot rely on the pandemic as they were aware about this situation before passing the bill, because you all are aware that the pandemic came in 2020. So, and department, again the SSC held the department cannot use the administrative power to issue notification for extension of due date under section 148 on the basis of Relaxation Act. And SSC also argued that section 3(1) of Relaxation Act is non-obstance clause. On the contrary, the revenue has stated that the argument by SSC was incomplete and ignorance of the background, as this is once in a 100-year emergency called global pandemic. And revenue also submitted that the section 3(1) of Relaxation Act was an example of conditional legislation, and the department also submitted that these notices issued through Relaxation Act as permissible, and is it not kind of stop the clock. What is stop the clock? Means any particular date will be all kind of act will be stopped at particular date. And the department also submitted that those relaxation was not provided to for issuance of such notices. The department held that the tax it was also relaxation was also provided to for various due dates, because everyone was kind of affected by this COVID-19. So it is not just that in order to safeguard itself from issuance or to meeting the time limits for issuance of notice, the department has issued so-called 148 notices, but the department or income tax the revenue has also granted time limit, extended the time limit for filing of various compliances. So the court has heard both the case like parties, revenue as well as the SSC, and the court has held that according to Finance Act 2021, the new provision shall come into force on such date as the central government may, by notification in the official gazette, may apply. The memorandum to financial bill also explain that the substituted provision of the act will effect from 1st of April 2021. The law prevailing on the date of issue shall apply, which means that the notice is issued for any assessment year on or after 1st of April 2021 have to comply with new provisions and not with old provisions. And the condition for, like I already explained, the condition for new provision is to comply with the provision of section 148A. Further, the section 3 of the Relaxation Act 2020 is not the stop the clock provision, means allow extra time by temporarily ceasing the count of time before any kind of deadline. So as it only relaxes the time limit, so to facilitate the cases in which the revenue has not been able to take the specified action within the specified time limit, that was 31st March 2021, which was time barred matter for old cases. So therefore the reassessment notices issued under section 148 of the act after 1st of April 2021 under the old provision shall be quashed and old provision shall be revoked. So through this case law or this judgment, the court has provided relief to more than 1300 SSC, but it is private, I would say private rate, so this will not be applicable to general public. What I'm meaning means thereby the only SSC or taxpayer who have filed a writ will be able to take the benefit of this relief. If I'm going to if I am going to take this position before the tax officer, then simply the tax officer is not going to accept my contention, although I can also file the writ petition before Delhi High Court if my jurisdiction in Delhi or any other court wherever my jurisdiction is situated, and thereafter the court may consider the facts and they may issue a favorable order. But since there are contrary decision, three in favor of SSC and one in favor of revenue, so definitely department is going to take this matter before the apex court, and we can only wait, because you might also know that there are like no notebandi also happened in that period, and the department's stake is quite very high. So I don't think the department is going to accept this decision, and definitely going to fight with all his guards before the Supreme Court. But for the time being, this case law or this pronouncement has provided relief to various SSCs who have gone for through writ petition. So this is first case law, and it is very important with respect to reassessment procedure. So now coming to the second case law, this is with respect to education cess. So this is issued by Kolkata ITAT in case of Kanoria Chemicals and Industries. So prior to discussing this case law, let me brief you what is allowable expenditure as per Income Tax Act. So Income Tax Act simply says all kind of taxes, like direct taxes, are not to be treated as allowable expenditure, and for that they have special section under section 40A subclause 2. So in the prior to this case law, there were two favorable High Court judgment wherein the court has held that education cess is an allowable expenditure as it does not fall under the category of taxes. So even various SSC has taken this ground or in the form of additional ground before various ITAT or High Court. High Court cannot, I would not say High Court, before various ITAT or during the course of assessments. So in this case also, the SSC company has claimed education cess as an allowable expenditure, and as per the income tax, the SSC has submitted that as per the provision of income tax, any rate or tax levied on the profit shall not shall be allowable as expenditure, but if it is education cess relying on those high court judgment. So the contention of SSC that the cess has not been mentioned in the provision of Income Tax Act and therefore it should not be disallowed. And the SSC also relied on the CBDT circular dated May 18, 1967 and said the circular said that it interpreted that the cess shall not be disallowed. The SSC also relied on those two High Court judgment. On the contrary, the revenue has submitted that education cess should not be allowed as deduction as it is it forms part of surcharge, and surcharge is nothing but an addition to taxes, so therefore it is also be treated as taxes. So there were the court has considered commentary of Finance Act 2004 and 2011, wherein it has been categorically mentioned that education charge is nothing but part of surcharge. So the basis those commentary to Finance Act, the court has consider heard both the revenue as well as SSC, and the court also take the cognizance of Honorable Supreme Court ruling in case of K. Srinivasan, wherein it has held that surcharge is nothing but an additional part of tax. So once the cess or education cess is treated as surcharge, then it will be treated as part of income tax. And basis that the court has held that education cess is in the nature of additional surcharge, therefore not deductible under section 1440A subclause 2 of the Act. So this case law also going to having impact on most of the SSC who has taken the additional ground before various ITT or during the course of assessment, and this was earlier not brought down. The court also held that this fact of surcharge was not brought down before the notice of High Court, which has pronounced the order in favor of SSC. So, but although since it is an ITAT judgment, the SSC may definitely going to take this position till the matter or specifically discussing this education cess by any of the High Court. Third case law is Mumbai ITAT in case of state of Ram Nikal Rajmal Mehta versus DCIT. So this is nothing but based on the technical glitches faced by the SSC. Let me tell you the background. The SSC has filed an appeal before the CIT in physical form because the father of the SSC the SSC was died, and on his behalf his legal heir has filed the appeal, and he also got new pen, but the department or the software or utility was not accepting his appeal, and he, after multiple try, he was not able to file the appeal in online manner. So therefore, but the department has completely rejected the physical appeal, and it has stated that as per the new provision or as per the rule 45 of the IT rule 1962, the appeal is required to be filed only in electronic form, and the SSC is duty bound to file the appeal in electric form. And he also mentioned that since the SSC was able to file the return of income in electronic form, even after the demise of his father, it means the state is still functioning and he needs to file the CIT appeal in electric form. The ITAT has take the heard both the party, and the ITAT has held that SSC has tried all his sufficient and sincere effort to file the appeal in electric form, but due to failure or some technical glitches on part of income tax department, he was not able to file, or the non-filing of electric appeal was on account of inaccessibility of income tax portal. So therefore the SSC was left with no other option other than to file the appeal in physical form. Therefore the revenue cannot take the benefit of non-functioning or malfunctioning of its portal and deny the statutory rights of the SSC. Therefore, the ITAT has decided the matter in favor of SSC and set aside the order passed by CIT and consider the physical appeal filed by the SSC. So it is again kind of principle of this case law may fall under the principle of natural justice, and it has in various cases it has been held that wherever there is a technical glitch on part of department, then the SSC cannot be denied the right to be heard. So this case law is coming in line of those judgments, earlier judgment. This case law was issued by Gujarat High Court in case of Karthik Vijay Singh, and it is very important as well as interesting case law. So in order to tell you the background, the petitioner was at a pilot, and many of you or all of you might be aware that there was Kingfisher Airlines operated by Vijay Mallya, which got bankrupted or so insolvent. So the petitioner was a pilot with Kingfisher Airlines for the period 2009, 10 and to 11, 12. So the TDS was deducted by the employer, but Kingfisher has not deposited that TDS to the government account. So once the matter of the SSC got selected for scrutiny, they have issued the notices for TDS recovery from the SSC, which is pilot in our case. So the pilot or the SSC has held that TDS was already deducted by the employer, and it is the duty of employer to deposit those taxes and not the employee or the taxpayer. So the court has very interestingly take the cognizance, and it has held the contention. First, the contention of SSC was that the obligation of the employer to deposit of TDS and the consequences of failure to do the same should not be imposed on him. On the contrary, the revenue has stated that the respondent was of the view that it was duty of petition to join the necessary party, and all the blame cannot be taken on the Kingfisher Airlines and the employer. Although the employer had deducted the TDS and not deposited the same to the government, but there was also failure on part of taxpayer, since the amount was not reflecting in Form 16. The court has heard both the parties, and the court held that after the deduction of taxes, SSC only gets a certificate to that effect by person responsible to deduct the taxes. In a case where the amount has been deducted by the person responsible to deduct the amount, under the statutory provision, the SSC has no control. What I mean that once the TDS has been deducted by the employer, it is the duty of employer and not the employee. Means the employee cannot force the employer to pay or to deposit the taxes when it has already been deducted from his account. Therefore, the proceedings should be allowed against the deductor and not against the employee or like deductee. The court further held that the credit, so this is very important, even though the amount was not deposited with the government, the court has held that credit of those taxes which was deducted from the employee's account should be allowed to the SSC along with the statutory interest, and the department is precluded from denying the benefit of TDS. Means they cannot recover, or they should grant the refund if TDS has been already been deducted by the employer. And if they want, then if they want, they can recover that amount only from employer, but the employee cannot be held liable or cannot be denied the benefit since TDS has already been withheld from the employer. This is Delhi ITT judgment in case of Dow Jones and Company. The matter for consideration with respect to royalty and FTS, I would say royalty only. So the appellant company was incorporated in USA and engaged in the providing services of containing global businesses and financial news. Dow Jones, you all, or many of you might have heard. So it offers information via newspaper, newswire, websites, application, newsletters, magazines, proprietary database, radio, etc., etc. The appellant company appointed Dow Jones Consulting India Private Limited on a principal to principal basis for distributing its product in the Indian market. Accordingly, the appellant company, Indian company, receive purchase price from Indian company at an arm's length price. The contention of the AO was during the course of assessment proceeding, the assessing officer was of the firm belief that the receipts from Indian companies should be taxed as royalty income under the provision of India USA DTAA, and that has also referred Indian tax provision under section 9 subsection 1 clause 6 of the Income Tax Act. The assessing officer treated the Indian receipt as taxable as royalty. So I would say all directly or indirectly, like all kind of trademark or utilization of software would be treated as royalty under the income tax law, but the relief only received from DTAA provision, and wherever there is contradiction or between Indian tax laws and DTAA, whatever is more beneficial or favorable to the SSC will always be supersede. Means if I would say, if the tax rate in Indian tax laws is 20%, but the tax rate on same type of income is 10% as per the DTAA, then DTAA shall prevail. Vice versa, if the rate in DTAA is 15% and rate as per Indian tax laws or domestic tax law is 10%, then we will always prefer the Indian tax law, because means what the principle is that nothing but the favorable position should be taken. So whatever is more beneficial to the SSC, we need to consider that situation. If the DTAA is more favorable, then we need to consider the tax rate or taxability as per the DTAA. And if Indian tax law is more favorable, then we need to consider the taxability or tax rate as per Indian tax law. And there is one more like very famous make available condition, which is first I would say that in general term I would say what is make available, but that is pertaining to FTS. So make available is nothing but I would say if some person has provided to services to some other person or employees, and those other person are entitled or are in a position that they can use those, or they can use those services, or they are in a position to produce or those services at their own, means they don't need the support of like, if I would say there's person A and B, and A teaches some services to B, but from next time the B don't needed the teaching of A, means he can apply those services at his own, then the condition of make available is satisfied. So this is also very important from like royalty FTS point of view. So in this case, the SSC has contested that the SSC has received nothing but the merely an access of database, and it used its copyright, and it has not given any copyrighted. So therefore, the impugned receipt cannot be treated as royalty in the hands of SSC. ITAT had the ITAT has heard both the parties and pronounced that the SSC is entitled to invoke the provision of India USA DDAA, and ITAT also made the reference to Article 12, which talks about royalty, and held that unless the payment are made towards acquiring those right to use or copyright in a literacy, artistic, or scientific work, then the definition of royalty would not get triggered. Further, the end user in the present case cannot be said to have acquired a copyright right to use or the copyright in the data. Accordingly, the payment made by Indian company for accessing the database would not qualify as payment for the use of copyright. Thus, the said expenditure cannot be treated as royalty. So this is the Karnataka High Court judgment in case of ACIT versus Krupanidhi Educational Trust. In the background, the fact of the case was SSC was in charitable trust running an educational institution. So I had already mentioned in the last or prior to last discussion or presentation that there are mainly 5 limbs or type of charitable activities like yoga, medical relief, education, general public, and these type of relief to poor. But there is one last clause: any other relief provided in the nature of charitable purposes. So what happened in this case, lo? In this case, there was amendment to the trust deed. So the court basically the amendment was made without the prior approval department and agreed by that the tax officer has held that since you have made the changes in the object clause, therefore the registration got cancelled. So in the contrary, what was the contention of SSC? The SSC stated that the amendment of the object of the institution are not in contradiction of the original object, which were prevailing at the time of granting registration. The ITT had compared the ITT had compared the original trust deed and amended the trust deed and held that the amended objects are in nothing but in accordance with the main object of the trust. The proviso 215, which pertains to carrying on activities in the nature of trade, commerce, or business, are not applicable to the SSC as it is engaged in the charitable activities of imparting education. So this trust fall under the education limb, and in this regard, Reliance was also placed on children education housing society case law to support that the contention that the no parameter was set out in section 12AA3, and therefore registration cannot be cancelled. On the contrary, the revenue has contested that the SSC had made certain payments and commission to brokers for getting students admitted. It had also given loan or like payment made in cash, and assessing was not maintaining proper books of account, and also it also purchasing luxury cars for its trustees, which indicates that it was involved in commercial activities, and it also clear breach of section 13(1). So what is 13(1)? If trust like provide special benefit to trustee or their relative, then the condition of 13(1) got breached, and in that case the registration of trust can also be cancelled. And the revenue also contested that the SSC had made changes to the object and it had carried out amendment in the trust deed without prior approval of department. Revenue also relied on Karnataka badminton and few other case laws. The High Court, after hearing both the parties, has noted that as per section 12A of the registration, the registration of trust can only be cancelled in those cases where the activities of trust are not genuine and such activities are not carried out in accordance with the object of the trust. Means till the time the object clause is satisfied, means if it is involved in education and it is satisfying its educational purposes, then the registration cannot be cancelled. The High Court also held that the receipt of commercial activities are more compared to the overall receipt of charitable institution can neither lead to conclusion that the activities of trust are not genuine, nor it can be held that the activities of trust are not being carried out in accordance with the two above mentioned condition. This is that the High Court has dismissed the appeal of revenue and granted the registration, revoked the cancellation order. So what is the crux of this case law? It is that till the time if even if there is any amendment in the object, but till the time the object, the activities of trust is in sync with the main object of the trust, then the registration cannot be cancelled. So now our first part has completed. That was pertaining to case laws. Now coming to the second part, which is mainly related to circular and notification. So first I'm going to discuss the National Faceless Appeal Scheme 2021. So it is a revised scheme. The earlier scheme was also issued in 2021, 2020, and the scheme has amended in 2021 because there were various technical glitches, or I would say there were so many issues was faced by the SSC. So therefore the department has taken the cognizance and revised the scheme. So what, first of all, what is the scope? So like similar to assessments, all the appeal will also be carried out in electronic form only, and the scope will be applicable to all the territorial areas, means it is applicable to all India. And similar to assessment, there would be various faceless appeal centers, which will be called as National Faceless Appeal Centers. So in short, we can say them NFAC. What is the procedure? The procedure, it is procedure I am not going to discuss, and no personal opinions. Similarly, since it is in in electric form, and it was bring in order to provide more transparency and accountability and reduce some corruption. So there would be no physical hearing. The hearing will be done only in electronic form through video conferencing. So what is the coverage? These appeal covers rectification matter, appeal matter, and penalty matters. So what is the main difference? This is important. Prior to, so as I already told, the first scheme, faceless appeal scheme came in 2020, and now this is revised scheme in 2021. So the main difference is in 2020 scheme, for providing any personal hearing through video conferencing, the approval of Chief Commissioner of Income Tax or Director General in charge of regional faceless appeal center was required. But in this scheme, if the SSC opt for personal hearing, or if if he requests for personal hearing, then the commissioner himself shall allow the request for personal hearing, and he does not require any personal approval of CCIT or Director General. Under the old scheme, the jurisdictional CIT shall be vested, the jurisdiction of particular area was vested with a jurisdictional CIT, but in new scheme, it is conducted through centralized manner. Means the Delhi case can be heard by a CIT situated in Bangalore, or a CIT situated in Calcutta can also heard the matter of SSC situated in Mumbai. So it is centralized scheme, like similar to assessment. Appeal unit. So there are certain kind of unit also which determine and check. So prior in the earlier scheme, there can be more than one commissioner, but in the new scheme there will be only one commissioner. So this is procedural part. I'm not going to discuss because you may read this. So coming to the next notification, this is also important. The department or government has provided one-time relaxation for verification of all the income tax return e-filed for last assessment year, that is AY 2021. So the government has even I have also seen for various SSC, even though we have already verified the return, but it is still reflecting as not verified. So the government also taken the cognizance, and it has felt that they need to rectify this error, which may be due to either due to SSC or on part of government. So the government has provided relaxation, and now till the time of February 28 for earlier year AY 2021, we can verify all those return if it is not verified till date. This is search and seizure summary, which I don't think I need to discuss or explain. And it is income tax calendar for the month of January 2022. So this concludes my today's session.